Hi, Cassie.
Hello.
Can you see me?
I can.
Okay. So I guess I'll just wait for you to enable sharing on my side then.
Yeah. We'll give it just a few more minutes, let some people log in and get started.
Yeah.
Like about four. I usually give it about 2 minutes after the hour.
Okay.
Well, good afternoon and welcome to Third Thursday with GBLA. We are so excited to bring this webinar back to you guys. We're going to give it just another moment to allow those attendees that are still logging in, and we'll get started in about 2 minutes. All right, so we're going to go ahead and get started. So this is Third Thursday with GBLA. We are so happy that you can join us today. So today's presentation, we're going to cover animals and housing, and we have one of our fair housing attorneys, El Kazayan, with us today to present. Now, you did come in and your videos are off and your sound is currently muted. We will have an opportunity for questions and answers at the end. But please feel free to use the Q&A or the chat box to ask any questions during the presentation. Typically this is scheduled for an hour. It might take us, well into 30-45 minutes for the presentation. It might cut short, but we're excited to have you here today. For those that don't know, my name is Cassie Mullican. I am the Marketing and Communications Coordinator with Greater Bakersfield Legal Assistance. Here at GBLA, we provide free legal service to individuals that are low income and elderly and a variety of different civil services. One of the programs we have is our Fair Housing Law Project, where we actively investigate fair housing discrimination and represent clients on a case-by-case basis. So we're so happy to have you here today, and I'm going to go ahead and turn it over to our speaker today, Elle, and she's going to take you through our presentation.
Hi, I am El Kazayan. I am a staff attorney with GBLA's Fair Housing Law Project. And let's see, Cassie, I'm still not able to share my screen.
Getting there.
Okay. Okay. Let me just share my screen. Okay. Can you see my screen, Cassie?
Yes, we are good.
Okay. So as Cassie said, this presentation will be about assistance animals in housing. So the Fair Housing Law Project deals with housing discrimination, and one common issue in housing discrimination is the refusal to let a tenant with a disability keep an assistance animal. I will be going over the laws related to that issue today so that individuals with disabilities will know their rights, and also housing providers will be aware of their obligations, and that way they can avoid having discrimination complaints filed against them. So first, I want to give a brief overview of this presentation. I will primarily focus on California housing laws as they relate to assistance animals, but I will also discuss federal laws. There is a lot of overlap between California and federal laws, but there are some differences between the two, and some terms do have different definitions. I'm going to start with the key terms and their definitions. You need to know the legal definitions of the terms so that you can understand the assistance animal laws and so that you'll be able to use the proper language when discussing these laws. Next, I'll go over the laws that apply to all assistance animals because, as you will learn in the next slide, there are actually two different types of assistance animals under California fair housing laws. After that, I will move on to a discussion of each type and their different requirements. So we'll cover service animals first, then we will move on to emotional support animals. First of all, you should know what exactly is an assistance animal. There are a lot of terms thrown around and confusion about different terms, but under California fair housing law, the term assistance animal refers to both service animals and emotional support animals. So assistance animal is the broader term, and service animals and emotional support animals are the two different types of assistance animals. A service animal is an animal that is trained to perform a specific task to help an individual with a disability. Under federal law, only dogs and miniature horses can be service animals. California laws don't impose any restrictions on what animal can be a service animal, though. So examples of a service animal would be a guide dog for a blind person, a dog trained to remind someone to take their meds, a dog for a person with PTSD that is trained to lick that person's hand as an alert before a panic attack, or a dog for a person with epilepsy that is trained to recognize when a seizure is about to happen and then to help that person stay safe during the seizure. An emotional support animal, or an ESA, is an animal that provides comfort or emotional support to a person with a disability. Any type of animal can be an ESA. They're also known simply as comfort animals or just support animals. So the key difference between service animals and emotional support animals is that service animals are trained to do something while ESAs are not. The mere presence of an emotional support animal is enough for the person with a disability. Next, you need to know the legal definition of disability, because assistance animal laws apply only to people with a disability. They don't protect the right of a person without a disability to have a pet. Under California Fair Housing Law, a disability is defined as a mental or physical condition that limits at least one major life activity. Now, federal law has a more restrictive definition of disability. Under federal law, the mental or physical condition must significantly limit a major life activity. So if you're in California, the mental or physical condition does not need to have a significant impact. It just needs to limit a major life activity. This is an example of where it's important to know the difference between California and federal laws, because in California, more people would qualify as having a disability under California's definition of that word. A condition limits a major life activity if it makes achieving the activity difficult. So I just listed, major life activities of daily living, caring for oneself, social activities, mental activities, walking, seeing, hearing, speaking, reading, learning, and working. Assistance animals are medical tools, not pets. Therefore, the normal pet rules that a housing provider might have do not apply to assistance animals. Legally, they're considered a completely different category with their own set of laws. So a person with an assistance animal may not be required to pay any pet deposits or fees, additional rent or fees, including additional security deposit or liability insurance, in order to keep their animal. Also, a housing provider may not restrict the breed, size, or weight of the animal. If the animal damages property, that's addressed through the usual security deposit rules. The owner of the animal is responsible for damage that its animal causes, but not including ordinary wear and tear. An assistance animal must be under the control of the person with the disability. Housing providers may require the tenant to pick up after the animal, ensure proper waste disposal, and ensure it does not cause a nuisance. Housing providers may also require the tenant to restrain the animal in common areas, unless doing so would impede the animal's ability to perform its tasks. So for example, a leash can't be required if it interferes with a guide dog's or service dog's work to help the person with the disability. And in that case, the animal could be under voice control or another method of control. Assistance animals do not need to be certified or registered as an assistance animal. Buying a certification or registration online does not prove that an animal is either a service animal or an emotional support animal. These documents, they do not convey any rights to individuals with assistance animals. All the service animal training and certification programs are operated by private businesses. There is no California or federal entity that certifies an animal as a service animal or an emotional support animal. They're also not required to wear a vest, harness, or ID to indicate that they are an assistance animal. A person can have more than one assistance animal, but each animal must meet the requirements for either an emotional support animal or a service animal. We will go over the requirements for each in later slides. Some examples of when a person might have more than one assistance animal would be a person who is blind and uses a guide dog may also have another dog that alerts him before he has seizures, or a person who has a service animal to remind her to take her meds might have another animal just for emotional support. There are multiple laws that may apply to assistance animals. There's the Fair Housing and Employment Act. That's California's law that prohibits discrimination in housing and employment. There's the Fair Housing Act, which is the federal law that prohibits discrimination in housing. We also have Section 504 of the Rehabilitation Act, which prohibits discrimination by federal agencies and recipients of federal financial assistance. And then there's the Americans with Disabilities Act and the Unruh Civil Rights Act. Now let's focus on laws that apply specifically to service animals. Service animals are working animals. People with a disability have a right to have them subject to a limited inquiry. So tenants, occupants, guests, and others are permitted to have service animals in all dwellings subject to certain restrictions, which we will go over. The only questions that a housing provider may ask to determine if an animal is a service animal are: one, are you an individual with a disability? And two, what is the disability related task the animal is trained to perform? But you may not ask these two questions if the disability related need for the animal is obvious. For example, you would not ask these questions of a blind person who uses a guide dog or of a person in a wheelchair that is being pulled by a service dog. You may not ask the individual with a disability to demonstrate the animal's task or ask about the nature of the disability. Housing providers may not require additional verification or certification for service animals. They also don't need to be professionally trained. An individual with a disability can train her own service animal. All right, a service animal does not need to be allowed if it poses a direct threat to the health or safety of others, and that means a significant risk of bodily harm, or it would cause substantial physical damage to the property of others, and a reasonable accommodation cannot sufficiently reduce or eliminate that harm. This means that you may not automatically ban an animal that is a direct threat or would cause substantial physical damage. You first have to consider whether a reasonable accommodation could reduce or erase that harm so that the animal could be allowed to stay on the property. The determination has to be made on a case-by-case basis and should be based on observable evidence about that particular animal's conduct. You may not consider evidence that is so old that it's not credible or reliable. You also may not base the decision on stereotypes or generalizations about certain breeds or types of animals, such as all pit bulls are dangerous, so this pit bull has to be dangerous. So that's not permitted. The decision can't be based on mere speculation or fear about the types of harm an animal might cause or on evidence of harm that other animals have caused in the past. In deciding whether a specific animal is a direct threat to others' health or safety, or would cause substantial damage to others' property, a housing provider is required to consider these three factors. One, the nature, duration, and severity of the risk of a direct threat to others' health or safety, or of substantial property damage. 2, the likelihood that the animal would actually significantly harm someone or substantially damage another person's property. And 3, whether there are any reasonable accommodations that would mitigate or erase the risk that either of these things would actually occur. Now let's turn to emotional support animals in housing. So if you remember, an emotional support animal is an animal that provides comfort or emotional support that alleviates a symptom or effect of an individual's disability. Whereas service animals are permitted by right, and a housing provider may ask only 2 questions for the service animals, emotional support animals go through a different process. Emotional support animals are allowed in housing as a reasonable accommodation, while people with service animals do not have to go through the process of requesting a reasonable accommodation. So the legal definition of a reasonable accommodation is a change or exception to a rule, policy, or practice that is necessary to provide a person with a disability equal access to the service, program, or facility. And one of the most common accommodation requests is for a housing provider to change its pet or animal policies so that a tenant with a disability may live with an assistance animal. Under both federal and California laws, it is a discriminatory housing practice for a housing provider to refuse to make a reasonable accommodation that a person with a disability may need in order to have equal opportunity to use and enjoy a dwelling. When can a housing provider refuse to make a reasonable accommodation to allow a tenant to keep an emotional support animal? So the answer is the same as for service animals, but with the addition of 2 more reasons. So just like with service animals, an emotional support animal does not have to be allowed if it is a direct threat to others' health or safety, or if it would cause substantial physical damage to others' property. Additionally, an emotional support animal does not have to be permitted if doing so would result in an undue financial and administrative burden, or would fundamentally alter the housing provider's business. So those 2 additional reasons, they typically don't come into play with requests to keep emotional support animals, because allowing a tenant to keep an emotional support animal, that generally does not fundamentally alter a housing provider's services or impose an undue burden on them. When a person requests a reasonable accommodation to keep an ESA, the only information that housing providers may ask for are 1, verification that the person does have a disability, and 2, verification that the person has a disability-related need for an assistance animal. However, housing providers are not legally required to ask for this information. Housing providers are not allowed to request information if the disability or the disability-related need for the animal is readily apparent, meaning visually obvious, or if the housing provider already has information confirming the individual's disability and disability-related need for the animal. What should the verification include? The verification should include the verifier's relationship to the person with the disability. It should state that the person has a disability, which, if you remember, is defined as a mental or physical condition that limits a major life activity. And it should state that the person may need the animal because it provides emotional support that helps with the disability. Housing providers are not allowed to request information that is unrelated to whether the person has a disability or a disability-related need for an ESA. In considering a request to keep an emotional support animal, a housing provider may not require specific forms, notarized statements made under penalty of perjury, detailed information about the disability, like the person's diagnosis or how severe the disability is, medical records or history, and they may not require an independent evaluation or their own direct evaluation. So going back to the first bullet about forms, some housing providers have specific forms or certain procedures to process a request to keep an emotional support animal. But housing providers cannot refuse to allow a tenant to keep an ESA just because the tenant did not use the housing provider's preferred forms or preferred procedures. Who may verify that someone has a disability and a disability-related need for an animal? So, and a person can verify his own disability with documentation of disability benefits. And any reliable third party who has personal knowledge of the person's disability and or disability-related need for the animal may verify. A few examples are healthcare providers, medical professionals, therapists, social workers, peer support groups, non-medical service providers like in-home supportive services workers or supported living services providers. Even a relative caring for a child with a disability can verify for the child. And someone who is in a caregiving relationship with the person who has a disability can provide the verification as well. Verification letters from remote healthcare providers are becoming more common, and they are sufficient as long as the provider has personal knowledge of the individual's disability-related need for an assistance animal. Many of these providers do have this personal knowledge because they conduct phone assessments or video evaluations and therapy sessions before writing verification letters. Housing providers may not reject a verification letter just because it was written by a healthcare professional that provides services via the internet, the telephone, or other remote method. A person with a disability may request a reasonable accommodation at any time. They may make the request while applying for the unit, during the tenancy, or even during the eviction process, including at trial and after judgment. So let's say a tenant brought the animal onto the property before making the request and then received a notice to quit because the housing provider found out about the animal. In that case, the housing provider must still consider the request according to the rules for reasonable accommodations that we just went over. And the housing provider can't move forward with the eviction if the tenant is legally entitled to the assistance animal. In that case, the termination notice would have to be rescinded. Also, housing providers may not retaliate or take adverse action against tenants because they made a request after bringing the animal to the property. If the housing provider can't immediately grant a person's request to keep an emotional support animal, the housing provider must engage in an interactive process with the person or the person's representative to find an equally effective alternative. That means the housing provider is not allowed to just ignore the request, but must respond and make a fair and honest effort to discuss and consider the request. So the interactive process is required by California law. If the housing provider thinks that they have not received enough information to establish that a tenant has a disability or a disability-related need for an emotional support animal, the housing provider must request clarification from the tenant. An accommodation request may not be automatically denied without first requesting clarification or information from the tenant, and then giving the tenant a reasonable opportunity to respond. A housing provider's failure to timely respond may be seen as a denial of the request for an accommodation. So basically, housing providers must enter into a dialogue with a tenant if the housing provider has a problem with the request for an accommodation. Also, this is another important point. If an initial request to keep an emotional support animal is denied, and the individual with a disability later on makes that same request, a housing provider must consider the request again, independently of the first request, and must follow the same regulations we just went over regarding the interactive process. If you would like to learn more about assistance animals and housing, the following links are very informative. And that is the end of my presentation. Thank you for attending. And here is more information about GBLA's Fair Housing Law Project. We provide fair housing services in Kern County. Fair housing refers to illegal discrimination in housing. We're involved in community education and outreach. We investigate illegal housing discrimination, and we also help enforce fair housing laws by advocating with landlords, filing discrimination complaints with HUD, which is the Department of Housing and Urban Development. That's a federal agency. Or filing discrimination complaints with CRD, which stands for the California Civil Rights Department. That is the state agency that enforces fair housing laws. If you think that you're experiencing illegal housing discrimination, you may contact us online, by email, or at our website, by phone, or at our office. Thank you again for your time.
Thank you, Elle. That was fantastic information. So we'll go ahead and open up at this point for questions. There are several ways that you can ask a question. We have the chat box open, we have the Q&A box, or you can simply raise your hand and I can unmute you. So we'll give just a few minutes to see if we have anybody that has information or questions to ask. I do see one. Let me find you here. So we do have a question. So Gloria, it should allow you to unmute yourself.
So Colleen is asking if you will get a copy of the presentation. My understanding, Cassie, is that you will be posting the video online along with the slides, correct?
Yes, so we will have the slides available on our website. And in addition, this presentation was recorded and will be put on our YouTube channel where we can find the information out as well. And I'm trying to see, Gloria, it looks like your hand went down. I didn't see you able to ask the question. I don't see any other hands up in the attendee list. I don't see anything in the chat, and I don't see, oh, we do have one right here. And let me see here. I'm so sorry. This is a new system, so I'm trying to get used to it. There we go. As a caseworker, if we already have a disability certificate or letter from a doctor, can we sign a reasonable accommodation form for our client?
So again, the standard for being able to write, a verification for for a disability or a disability related need for an emotional support animal is that you have to have personal knowledge of the disability and the disability related need. So if you do have that personal knowledge because you've been working as a caseworker with, you know, that person and you have that relationship with them, then yeah, you can sign that.
Awesome. So we'll give another moment for any others. For those that raised their hand, I'm so sorry. If it didn't allow you to unmute, it's not giving me the option on my end. So we will need you to type the questions either in the chat box or the Q&A box, please. And I will definitely look into live questions for the next third Thursday. Okay, final call out. Oh, here we go. Can an ESA animal be a farm animal like a rooster?
Yes, there are no restrictions on what animal can be an ESA. If there are zoning laws in the county, though, that person would need to get some, you know, permission from the county if there's a zoning law that they are not allowed to have roosters. But yeah, a rooster can be an ESA.
And just to elaborate a little bit more on that, City of Bakersfield at this time does not allow certain animals due to zoning laws. And so what Elle is referring to is you can actually go to the city manager's office. I don't think it's a city manager, but you can go to the city and put in a request to have that evaluated.
So Colleen, my presentation was specific to housing. I can't speak to, you know, other situations, so I'm just addressing housing right now.
So the question is, were the questions that one can and cannot ask specific to those dealing with housing, or are those general questions that everyone is and is not allowed to ask? And so as Elle just answered, we only covered housing. You'd have to probably reach out to the California Civil Rights Department for more information, or another agency that handles ADA issues. So we'll do another final call. If you have any questions, please put them in the Q&A or in the chat. Okay, so we're going to go ahead and wrap up there. Again, thank you guys all so much for attending Third Thursday with GBLA. Stay tuned. We'll be back in October. We've not decided on a theme or a presentation yet, but please feel free to reach out. You should have received my email, kmullican@gbla.org, when you register for this webinar. Please feel free to send me a message and let me know what type of information you guys would like to seek. Do note that we do try to keep it within our areas of practice. And if we don't offer that service, we do make every attempt to reach out to other individual private attorneys to provide that information with their area of expertise. So I'm going to go ahead and call this to a close. Thank you all so much for attending, and we will see you next month.
Thank you, Cassie.
Thank you, Elle.